Question 736. Which of these types of loan could have variable amortization? A. Cal-Vet. B. Fannie Mae. C. VA. D. Any of the above. Correct answer is D. Any of the above. The concept of variable amortization typically refers to loans where the interest rate can change over time, leading to changes in the payment amount and how that payment is applied to principal and interest. This is most commonly associated with adjustable rate mortgages, ARMs. Cal-Vet loans are specific to California veterans and often feature competitive fixed interest rates. While some programs might have adjustable features, the general characteristic of a Cal-Vet loan is not variable amortization. Many are fixed rate. Fannie Mae is a government-sponsored enterprise that purchases and securitizes mortgages from lenders. They set standards for various loan types, including adjustable rate mortgages, ARMs. Since ARMs have interest rates that adjust periodically, their amortization schedule, the breakdown of principal and interest payments over time, will also vary. Therefore, Fannie Mae does deal with loans that have variable amortization. VA loans are guaranteed by the U.S. Department of Veterans Affairs. While many VA loans are fixed rate, VA also offers adjustable rate mortgages, VA ARMs. With a VA ARM, the interest rate can change, which in turn causes the amortization, and therefore the monthly payment, to vary over the life of the loan. Since both Fannie Mae and VA offer adjustable rate mortgages, ARMs, which inherently have variable amortization due to changing interest rates, the correct answer is D. Any of the above. Question 737. In Southern California, most escrows are performed by A. Attorneys. B. Separate escrow and title companies. C. Property managers. D. None of the above. Correct answer is B. Separate escrow and title companies. Here's a breakdown of the typical practice in California. 1. Independent escrow companies. Southern California predominantly uses independent escrow companies. These are specialized, licensed, and neutral third parties whose sole business is to facilitate the closing of real estate transactions. They are regulated by the California Department of Financial Protection and Innovation, DFPI. 2. Title companies. While title companies primarily provide title insurance, they often have an escrow division or work very closely with independent escrow companies. In some cases, especially in Northern California, the escrow function is more frequently handled directly by the title company's escrow department. However, the question specifically asks about Southern California. 3. Attorneys. California is generally considered an escrow state, not an attorney state. While attorneys can be involved in real estate transactions, and it's often advisable to have one for complex deals, they typically do not perform the escrow function as a neutral third party holding funds and documents in the way a dedicated escrow company does. In attorney states, attorneys directly handle the closing process. 4. Property managers. Property managers handle the ongoing management of rental properties, including collecting rent, arranging repairs, and dealing with tenants. They do not typically perform escrow services for the sale of property. Therefore, the vast majority of real estate escrows in Southern California are handled by licensed, independent escrow companies, often working in conjunction with title insurance companies. Question 738. Of these mortgage providers, which one generally offers the highest loan-to-value ratios, LTV, for conventional loans? A. Savings banks. B. Private lenders. C. Life insurance companies. D. Commercial banks. Correct answer is A. Savings banks. While savings banks, commercial banks and insurance companies are the largest providers of real estate loans. Savings banks best known for specializing in funding home mortgages. Traditionally, savings banks, or savings and loans, were specifically focused on residential mortgages. This specialization often led them to offer highly competitive terms for conventional loans. This included providing some of the highest loan-to-value (LTV) ratios in the market. While commercial banks also offer conventional loans, savings banks historically aimed to make homeownership more accessible. They often did this by structuring loans that required smaller down payments. This practice resulted in higher LTVs for borrowers. Question 739. The state's Fair Employment and Housing Act is also called the A. Rumford Act, B. Holden Act, C. Unruh Act, D. Employment Protection Act. Correct answer is A. Rumford Act. The state's Fair Employment and Housing Act, FEHA, is a comprehensive California law. It provides broad protection against discrimination and harassment. This protection extends to both employment and housing. While FEHA is its formal name, it encompasses and was built upon earlier fair housing efforts. Specifically, the Rumford Act was a significant precursor focusing on housing discrimination. The Unruh Act also plays a role, prohibiting discrimination in all business establishments, which includes housing providers. The Rumford Act, 1963, was California's primary fair housing law that prohibited discrimination in the sale, rental, and financing of housing based on race, color, religion, national origin, or ancestry. It was a crucial predecessor and its principles are largely incorporated into FEHA's housing provisions. The Unruh Act, 1959, broadly prohibits discrimination by all business establishments, which includes real estate businesses and housing providers, based on various protected characteristics. The Holden Act, 1977, specifically addresses housing financial discrimination, redlining. The FEHA incorporated and expanded upon the protections of the Rumford Act. Question 740. Gordy's 10-year-old Chevrolet broke down again, and in disgust he said to his friend, Steve, "I'll sell you my orange Chevy for $10. When Steve produced the cash and asked Gordy for the keys, Gordy refused to accept the money and said he'd only been joking about selling the car. If Steve sues his now ex-friend Gordy to go through with the transaction, the court will base their ruling on A. Whether a reasonable person would have believed Gordy's offer to sell his car for $10 was genuine or a joke. B. Whether Steve had believed Gordy's offer to sell his car for $10 was genuine or a joke. C. Whether an automobile dealer would appraise Gordy's car with a value of $10. D. Whether the car would be able to run the next time Gordy tried to start it. Correct answer is A. Whether a reasonable person would have believed Gordy's offer to sell his car for $10 was genuine or a joke. This scenario touches upon the legal concept of offer and acceptance in contract formation, specifically the element of contractual intent. For a valid contract to exist, there must be a genuine offer and acceptance, and both parties must have the objective intent to be bound by the agreement. Courts generally apply the objective theory of contracts. This means they look at the outward expressions and actions of the parties, rather than their secret, subjective intentions. The question is not what Gordy privately intended, but what a reasonable person in Steve's position would have perceived Gordy's intent to be. If a reasonable person would have understood Gordy's statement as a clear joke or made in jest, then there was no genuine offer, and therefore no contract. However, if a reasonable person could have legitimately believed it was a serious offer, even if impulsive, then contractual intent might be found. The extremely low price, $10 for a car, even a broken one, would be a key factor in assessing reasonableness. While Steve's belief is relevant, the court won't solely rely on his subjective belief. The standard is objective. What would a reasonable person have believed? The car's operational status is irrelevant to whether an offer to sell was genuinely made and accepted. Therefore, the core issue the court will examine is the objective manifestation of intent, judged by what a reasonable person would infer from Gordy's words and actions. Question 741. When a seller accepts the actions of an agent, even without a previous agreement, then an agency may be created by A. Oral agreement, B. Implied agreement, C. Express agreement, D. Ratification. Correct answer is D. Ratification. While an oral agreement can create an agency relationship, it's not the specific scenario described in the question. An implied agreement can also create an agency relationship, but in this case, the seller's acceptance of the agent's actions would be the more relevant factor. An express agreement is a written or oral agreement that explicitly creates an agency relationship. While this is possible, the question specifically mentions a situation where there was no previous agreement. Ratification occurs when a principal, in this case, the seller, accepts the actions of an agent, even if there was no prior agreement to create an agency relationship. This can happen if the principal benefits from the agent's actions or fails to object within a reasonable time. Therefore, ratification is the most appropriate answer in this context. Question 742. Regulation Z. A is also known as the Truth in Lending Act. B. Governs the Zoom rate, the interest rates for high-yield bonds. C. Requires that borrowers be informed of the true costs of credit. D. Both A and C. Correct answer is D. Both A and C. The Zoom rate is not a term associated with Regulation Z. It might be a term used in a different context, such as finance or investments. Regulation Z is the common name given to the set of rules issued by the Federal Reserve Board, now the Consumer Financial Protection Bureau or CFPB, to implement the Truth in Lending Act, TILA. So, they are inextricably linked. Regulation Z's main goal is to ensure borrowers understand the true cost of credit. It mandates that lenders clearly disclose all relevant terms, such as the annual percentage rate, APR, total finance charges, and the total amount to be paid. This empowers consumers to make informed financial decisions. Question 743. A pest control inspection of a property in escrow finds no termites, but conditions are discovered which might lead to an infestation later. Whose responsibility is it to pay for correcting these conditions? A. The buyer must pay for the conditions to be corrected. B. The seller must pay for the conditions to be corrected. C. The escrow company must pay for the condition to be corrected. D. None of the above. Correct answer is D. None of the above. In California, a structural pest control inspection report, often called a termite report, is not legally required for a property sale by state law. However, lenders often require it, and it's a common contingency in purchase agreements. These reports typically divide findings into two sections. Section 1 deals with active infestations or infections, like live termites or significant dry rot, and the damage they've caused. Section 2 identifies conditions that are conducive to future infestations or infections, e.g., earth-to-wood contact, excessive moisture, faulty grade levels, insufficient ventilation. The question refers to these Section 2 conditions. There is no legal mandate that requires either the buyer or the seller to pay for the correction of Section 2 items. This becomes a point of negotiation between the buyer and the seller, typically addressed in the purchase agreement or an addendum to it. The seller might agree to correct Section 2 items to make the property more attractive, to facilitate financing, or as part of the overall negotiation. The buyer might accept responsibility for Section 2 items, especially in a competitive market or if they are getting a good deal on the property. The escrow company's role is to facilitate the closing based on the instructions provided by the buyer and seller in their purchase agreement and subsequent escrow instructions. The escrow company does not have the authority to decide who pays for repairs unless explicitly instructed by both parties. Because this responsibility is negotiable and not legally set for either party, none of the above is the correct answer. The buyer and seller must reach a mutual agreement on who pays. Question 744. A contingency clause in an agreement should A. State a time limit for its conditions to be met. B. State how the parties will be informed of the fulfillment or waiving of the clause. C. Both A and B. D. Neither A nor B. Correct answer is C. Both A and B. A well-drafted contingency clause in a real estate agreement is crucial for protecting the parties involved. For a contingency to be effective and clear, it absolutely should. A. State a time limit for its conditions to be met. Without a time limit, a contingency could drag on indefinitely, creating uncertainty and delaying the transaction. A clear deadline ensures that all parties know by when the condition must be satisfied or waived. B. State how the parties will be informed of the fulfillment or waiving of the clause. Clarity on notification is essential. This prevents disputes over whether a condition was met or waived within the specified timeframe. Question 745. Which of the following statements is correct regarding a buyer's agent? A. Buyer's agents are not entitled to a commission. B. Being a buyer's agent is a non-permissible arrangement in California. C. Compensation for a buyer's agent may be provided by another party besides the buyer. D. Buyer's agents do not enter into fiduciary relationship with the buyer. Correct answer is C. Compensation for a buyer's agent may be provided by another party besides the buyer. In California, buyer's agents typically work on a commission basis. However, the source of that commission can vary. It's common for the seller to pay a commission to the listing agent, who might then share a portion of that commission with the buyer's agent. This arrangement is known as a cooperative sale. The important point is that buyer's agents have a fiduciary duty to represent the buyer's interests and may receive compensation from various sources. In fact, recent changes stemming from the NAR settlement have reinforced the need for clear written buyer agency agreements. While recent rule changes, like those stemming from the 2024 NAR settlement, aim to make buyer-agent compensation more transparent and directly negotiated with the buyer, it is still very common for sellers to offer to pay the buyer's agent commission as a concession or as part of the overall transaction to make the deal more attractive. The listing agent may also be authorized to pay the buyer's agent. So, the buyer's agent's compensation doesn't have to come directly out of the buyer's pocket, although the buyer is ultimately responsible for their agent's fee. A buyer's agent, like any real estate agent representing a client, enters into a fiduciary relationship with the buyer. This means they owe the buyer duties of utmost care, integrity, honesty, and loyalty, always acting in the buyer's best interests.